We are now live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Welcome to the Appeals Court, Mr. Corman, Mr. Steinfeld. Sitting with me today is Justices Kinder and Justice Ham, and I am Justice Meade, of course. We're going to proceed as best we can I don't know if you've argued on Zoom before, but sometimes we have had some technical difficulties. If that should occur, we will pause and we will try to reinitiate proper context should we have any problems. No one will lose any time on their argument. With that, I'll call the first case. It's 2019 P 1771 Commonwealth versus Matthew Swart. Mr. Corman.
Good morning, Your Honors. William Corman on behalf of Mr. Swart. The issue that I put forth was originally a relatively simple one. And I think the issue was whether or not there was a procedural misstep by the trial court in simply assuming that Mr. Swart was not competent and then essentially going through what Nieves allows the court to do, but without that predicate step. And I would suggest, as I did in both my brief and the motion for new trial, that was an error on behalf of the trial court. I know that the Commonwealth has said over and over again in their response that it doesn't matter because whatever rights Mr. Swart would have received were he found not competent were protected and preserved through the effective advocacy of trial counsel. And my suggestion respectfully is that really doesn't matter. The fact that we got lucky this go round and that all of his rights were protected and preserved through the articular arguments of trial counsel that really doesn't matter because we can envision a number of nightmare scenarios where an individual is not afforded the same rights and goals. I'm sorry, Justice Kinder. I couldn't tell if you had to interrupt. I haven't done this before. I didn't know if you had a question.
I don't yet. I think that I may, but not yet.
I apologize.
I do have a quick question, Mr. Corman. Could I ask, are you at this point taking the position that your client was not in fact harmed by this particular oversight in your view?
What I'm suggesting is that the net result doesn't really matter. The fact that he had a trial and that the trial in and of itself had certain procedural safeguards is irrelevant. There was a missing step. The fact that he was never deemed incompetent prior to trial counsel slotting into that role, even if we know, and even if we know that that's what would have happened, because I think the record is crystal clear that had there been an evaluation, had there been some sort of determination by a medical doctor or psychologist, I think it's crystal clear that Mr. Swart would have been found not competent. And then what happened next would have happened and would have been appropriate. The problem is that first step never took place. And again, my issue isn't that therefore in this particular case, things went in a different way. I do think that the steps need to be followed. The parallel I was trying to think of this morning is, we are all more than well aware of there are certain cases that go to trial simply because they must. The evidence is overwhelming. There's almost no question as to what's going to happen at the end of the day, but nevertheless, criminal defendants are afforded their right to trial. And in this case, it's almost the same analogy. If Mr. Swart had been evaluated for competency, he would have been found not competent, and then Judge Laureate would have done what he did. Yes.
It seems that from the transcript that Mr. Swart's lawyer at trial was of the position that it was of no consequence whether he's found incompetent or not, because the Commonwealth could proceed regardless of such a finding. And it seems that the Judge Laureate, as you know, a very experienced judge, he seemed to be quite cognizant of Nieves, and told counsel that she could substitute her judgment for that of Mr. Swart in making trial decisions, which would seem to be, as the Commonwealth maintains, an implicit finding that he is incompetent.
I understand that that's what the Commonwealth maintains in their brief. I think that it doesn't quite work that way. I think that other than an explicit finding of lack of competence, everything else that happened was appropriate. And what I'm suggesting is we simply can't gloss over the fact that there was no finding of lack of competence, or there was a finding of competency. We can't gloss over that. That is an important step. And again, that's why I was sort of going on the tangent I was a moment ago, because just because things worked out the predictable way in this particular case doesn't mean that we can gloss over what I would consider an important step. And
Mr. Corman?
Yes, Your Honor.
Let me follow up on that. I mean, it almost sounds to me as if you're suggesting that the absence of a finding was structural error and that there's no prejudice component whatsoever. Is that what you're suggesting?
Essentially, Your Honor. And I think that structural error is crucial in this case.
Is there any authority supporting that position?
Well, I think the answer is no. Well, I think it's going to be this case, Your Honor. I think that this is an issue that certainly in a sexually dangerous person context has never been addressed before. It's does there need to be a finding that the person isn't competent before we go through what Nieves allows us to do, which is to have trial counsel come in, substitute his or her judgment, and then the trial proceeds from there. But what I'm suggesting is that there needs to be that threshold showing. And as I put forth in, I suppose it probably would have been better as a 16L letter, but there was a recent case by this court, I think with Your Honor's participation in the Corbett case. And in the Corbett case, they basically say, Your Honors basically say, it's really not that hard to reach that threshold decision. I understand that some of the facts in Corbett are certainly different here, but in Corbett
case,
I'm sorry.
Was Corbett an SDP case?
No, it was a criminal case. It was a criminal case in the Barnstable District Court involving that.
This is a civil trial, so it's very different from a criminal trial.
Well, I would suggest to the court that it is civil, so there are some differences. But I would suggest that the SJC and other courts have talked about the fact that since liberty interests are at stake in SDP cases, that the protections that can be afforded through criminal trials are often applicable to SDP cases. The Parasu case, which is an SJC decision, talks about that. So again, as the court's aware, in Corbett, they let the conviction stand, but it's language in Corbett where they talk about the fact that or they reaffirm the notion that judges are not doctors, they're not psychiatric professionals. They talk about the fact that competency remains fluid, and they do say towards the end of that decision that the preference would be for a quick evaluation. This case, especially the SWART case, this wasn't some far-flung district court where they would have had to wait, a while for a forensic psychologist to come in. There's somebody in the building. I would suggest.
How do we know that?
Well, we know that
how do we know that?
That's fair. We know that the case was tried in Essex County Superior Court, as opposed to, a far-flung district court. But I think that if we go through the language in the Corbett decision, it tells us that in every court there is, if not someone there is the ability, a relatively simple ability, to have an evaluation done. It's I think within the first couple paragraphs of the Corbett decision, which again just came out in July. So I would suggest that the structural error here, as Justice Kinder has phrased it, and I think that's correct, is important, because although the net result would have been probably would have been the same, we simply can't gloss over the fact that this condition precedent, if you will, never took place.
Could I ask a question about structural error in the civil context, other than Doe versus Sex Offender Registry Board, which is cited in your brother's brief, I think? Are there other cases that you have to cite to us about the applicability of structural error in the civil context?
I'm going to say no with a caveat, which is no, because I am of the belief, and Your Honor certainly get to make this decision, not me, that the notion of sexually dangerous person cases fitting into the civil mold, if you will, it doesn't quite work, because although they are civil in nature, every single case where we talk about due process rights, where we talk about constitutional rights, where we talk about rights that are afforded respondents in sexually dangerous person cases, we talk about the fact that they are this unusual hybrid of both criminal and civil cases. So I think when we talk about structural error in this case, we really need to look at it from a criminal context as opposed to a civil context.
Just to follow up and clarify, Mr. Corman, I want to make sure I understand one thing. Assume that the judge had made an explicit finding that your client was not competent. Would the trial have looked different in any way?
I don't believe so. I don't believe so. But I want to sort of dial it back a little bit. I'm not sure that in this particular case, again, comparing it to Corbett, for example, I'm not sure that in this particular case, it would have been appropriate for the judge to make that decision. While competency was always an issue in the SWART matter, there had not ever been an explicit finding of lack of competence. There was a lot of conversations about the fact that he wasn't competent. There was a lot of conversations about his ability to participate in the trial and so on and so forth. Again, I'm contrasting it to Corbett, where there was an explicit finding that the defendant wasn't competent, or was competent, excuse me, at one point down the road. And there was some concerns that he was feigning incompetency when they went into court. So I suppose that's my answer without rambling too much.
All right.
If there are no further questions, then I'll simply rest upon my brief, and I appreciate you for your time.
Seeing none, thank you very much. Mr. Steinfeld.
You're still muted, Mr. Seinfeld.
Mr. Steinfeld, can you unmute your mic?
I'm very sorry about that, Justice Meade. May it please the court, Kenneth Steinfeld from the Commonwealth. The first thing, or one of the first things my brother said during his argument was, we got lucky this time around. And he maintained throughout his argument that the trial would not have been any different and that his client suffered no prejudice. He did not even allege prejudice in his brief, much less seek to prove that he had suffered any. The concept of structural error is not raised in this case. It is not raised by his brief. He does not mention it. He merely says, my client's rights were stripped, therefore I am entitled to a new trial, without identifying any such right. I am the one who brought up the issue of structural error in a footnote, as Justice Hand has noted, to point out that it was not raised here, that there are certain situations, very, very limited, in which that concept applies to civil cases. But it is not an issue. When my brother says, well, that's what's to be decided in this case, I strongly disagree with that. There is not only no support for the proposition that structural error occurred here, the issue is simply not raised. As to Corbett, I simply don't think Corbett has anything at all whatsoever to do this case in any sense whatsoever, because it's a criminal case and simply has no applicability whatsoever. But overall, the flaw that the defendant cannot overcome is the lack of an allegation of prejudice. And as the justices have pointed out, he got everything that he was entitled to, and the trial would not have been the same. I'm sorry, would have been exactly the same had there been a finding, an explicit finding. What his attorney sought was a competency evaluation, and then, if found not competent, the appointment of a guardian ad litem. And as Neve says very, very clearly, an appointment of a guardian ad litem is not the appropriate thing to do in this case. If found not competent, the issue then goes to the defense lawyer to make the decisions for him. Here, I think that it would be a fairly different case if defense counsel had said, yes, I'm going to exercise his right and go for a bench trial, and if the defendant then had objected and said, no, wait, I'm competent and I insist on a jury trial. Well, that didn't happen here. The defendant got exactly what he wanted. And as I said, he cannot show that there's any prejudice that arose from the fact that he got the jury trial that he wanted rather than the bench trial that apparently Ms. Kelleher would have preferred. I don't have any further comments. I'll be happy to rest of my brief. I'd be happy to take any questions from the court.
Just one quick one from me, Mr. Steinfeld. Are you suggesting that in an SDP case, a judge never has to address the issue of competency?
He never has to. Well, back up. I think there are times when he must, yes, there are times, and I think that then if he thinks there's a serious doubt about his competence, he can do exactly what the court did in this case, which was tell the attorney that she can make his decisions for him. But ultimately, as Ms. Kelleher said on the first day, it's of no consequence either way. But I think, as I said, the only problem would arise if the defendant wanted one thing and the defense lawyer wanted another and they argued about it. But I think in general, well, it's always helpful to have a competency finding. I don't think a judge would have abused his discretion by not finding explicitly whether or not he's competent. I'm not sure that that fully answers that question, and I think I changed my mind several times during that answer.
That's permissible.
Well, I'm just sort of thinking out loud here, but I think the phrase "of no consequence" is very important. I think that if there's an explicit conflict between the lawyer and his client as to strategy, then I think it's important for a judge to make an explicit determination, but otherwise not.
Thank you.
I'll be happy to rest of my brief, as I said, if the members of the court have no further questions.
Seeing none, thank you very much. We'll take this under advisement.
Thank you.
Thank you.
And can you hear us? Excellent. Thank you.
Okay. The next case is 2019 P 1178 Commonwealth versus DARGAN. Although these cases are paired, we're going to let both defense attorneys present their separate cases, and the Commonwealth can respond, and then you can follow up in the second case, Ms. Van Flatten, to the extent you see fit. So with that, Mr. Oskaren, can you unmute your mic? There you go.
Thank you. Good morning, and may it please the court. On behalf of Mr. Dargan, this is a very routine motor vehicle stop that eventually led to the discovery of drugs. I'd like to make three very quick points. Initially, the first one is that there is a very long line of case law dating back to the 90s that holds that when somebody's pulled over for a traffic violation, that the trooper can ask for license, registration, explain the reason for the stop. And then if nothing else is going on, either give the driver a warning, give them a citation, and let them be on their way. The only thing that could conceivably take this case out of that arc of cases, which starts with Commonwealth versus Torres in the 90s, goes up to Cordero a few years ago, is that in this case involved the trooper seeing a box that was labeled for ammunition. And I think the question for this panel is, does that box somehow remove this case out of the ordinary roadside traffic stop? Number two, I do want to point out in the motion judge's rulings, I believe he made errors both of fact and of law. In terms of fact, he stated that the trooper was conducting a protective frisk of the car for weapons. And clearly that's not what the trooper was doing. 3 times the trooper testified he was doing a motor vehicle inventory search. And in fact, at one point, the judge even asks him for clarification, is this an inventory search? And the trooper says yes.
But the Commonwealth is not justifying it as an inventory search.
That's right. They're justifying it as a protective frisk of the vehicle.
Right.
I'm simply saying when the trooper was explaining why he was doing what he was doing, his justification was an inventory search.
But it's an objective standard, though.
It is, but I believe that if it's an issue of, well, I'll get to that. I concede it is an objective standard. I would point out that the laws that the judge cited to in support that this was a protective frisk, none of those cases stand for the proposition that a box of ammunition sitting in the backseat of a car could legitimately raise a reasonable fear for safety.
What we have to take also into context what the trooper testified to about the box of ammunition, and that was ammunition by itself isn't necessarily dangerous, but it almost certainly comes accompanied with a weapon.
The trooper testified that typically he would expect to see the two together. That's correct. And I agree with you. In terms of asking, did the trooper have that fear for his safety and was it reasonable? This case is all about context. It's 1:30 in the morning. The trooper is sitting by the side of I-91 watching traffic heading northbound. He's roughly 5 miles or so below the Vermont border, and he sees a vehicle pass his location with New Hampshire plates. He gets behind it. One of the things that the trooper says is that not only does he see the driver flick out a cigarette onto the highway, but there's an object. He can't quite tell what it is, but it hits his windshield.
I thought it was a white bag that was thrown out the window that hits it.
He wasn't sure. He wasn't sure. But even if it were a white bag, I would suggest as we go through the facts of this stop, the trooper had a hunch that really there were drugs in the bag. And I think his actions really spell that out. He follows.
You don't argue that the stop was unjustified, right?
Not at all. Not at all. I argue that what the trooper did once he validly stopped the vehicle was unjustified because he was prolonging it. And how do we know that? He runs the vehicle's registration, sees that it's registered to somebody in New Hampshire. He speaks to the driver. The driver, and by the way, this is not a case where the occupants were appearing to be nervous. It's not a case where there were any furtive gestures. The trooper concedes that.
He is outnumbered. He is outnumbered. And it is 1:30 in the morning, and they do tell inconsistent stories, culminating in the female passenger saying they had just purchased drugs.
So it's 1:30 in the morning, and while he's outnumbered, you would think, and he does call for backup, you would think if he had a legitimate safety concern, he would have asked the backup trooper to come to the scene to assist him. But that's not what he does. He asks Trooper Teedy not to come to where they're parked, but to look about 2/10 of a mile back down the road to search for this white object.
But again, it's an objective standard. So we have to determine what a reasonable trooper in those circumstances could conceivably have a concern for his safety, the standard being exceedingly low under Gonzalez. And in this case, he's, like I said, it's 1:03 in the morning, he's outnumbered, he's found ammo that means, it brings a connotation of a weapon, and they're telling inconsistent stories, and they admit to purchasing drugs, or the woman does. Which is
let me say this.
Inconsistent with the story of coming from a casino.
I disagree that the stories were inconsistent. They differed slightly. The driver,
or having just purchased drugs, that's a big difference.
Well, with all respect, by the time that we get to the questioning of the female passenger, who eventually says, yes, the purpose of the trip was to get drugs. Let's look at what led to that. Number one, he orders the driver out. And instead of asking, you know, is there a gun in the vehicle, which would have been a legitimate question had he been concerned, what's his first question? Where are you coming from? And the motion judge said, well, that's just making small talk, but it's not, because he asked all three occupants when he ordered them out of the car, where are you coming from? He was following up on a hunch. Not only does he speak to the driver, he orders him into his cruiser, handcuffs him, asks where they were coming from. The driver says from the casino. He then goes back to the vehicle. And by the way, this is when he calls for backup. But if the issue is, was this for officer safety? The answer is A, no, because he wants the trooper to look for the white bag. And I would suggest to the court that Commonwealth versus Daniel, the 2013 SJC case says, an officer's actions may suggest whether a suspect's movements appear to be threatening to the trained eye. That's an objective question. In this case, if there were truly objective indicia that these people were armed and dangerous, he would not have asked Trooper Teedy to go a quarter of a mile away to look for a bag. He would have had backup come to the scene. Instead, he
doesn't have to have that concern. He only has to be concerned for his safety. The case law is explicit that he need not have any knowledge whatsoever that a weapon is actually there. And it means nothing in the outcome that there turns out not to have been a weapon.
Well, I'm suggesting that his actions are not consistent with an officer who did have a concern for his safety, because when he's speaking to the driver, let's say supposedly that he was concerned that there was a firearm in that vehicle which has been stopped. He's now putting the driver into his cruiser, handcuffing him. His attention is not focused on the car stopped in front of him with two occupants with potentially a firearm that poses a risk to him. His actions are inconsistent.
He's confronted with three individuals, and now he's taken one out of the equation by securing him in the cruiser.
But he's left two.
Let me finish. Why isn't that objectively reasonable on his behalf that illustrates a concern for his safety being outnumbered?
Because he's left two people in a car with the potential of a dangerous firearm unattended. The reasonable action.
Is there any evidence he was not paying attention to them?
I'm sorry?
Was there any evidence that he wasn't watching the two in the car when he secured Mr. Dargan or Mr. Tuttle in the cruiser?
Mr. Tuttle, he was never asked that question, but I would submit it's common sense. While you're handcuffing an individual with their hands behind their back inside a cruiser, his attention is not focused on those individuals. And I would also submit, had he truly had the concern that this is what he would have done, he would have ordered all three individuals in that vehicle to put their hands up in front where he could see them, to remain put until backup arrived.
Is there any evidence, Mr. Oskren, that is the required police procedure in those circumstances? Or is that your speculation?
I would submit that that's simply common sense for a trooper, that is the safe, prudent course of action.
So there's no evidence, though?
There is no case law that says that that's what a trooper must do. But there is case law that says we can look at a trooper's actions to see if, in fact, there was a reasonable objective fear for safety. And I would submit his actions would demonstrate that there weren't.
Mr. Oskren, can I ask a slightly different question? If we determine that the stop was not improperly prolonged, as you suggest, and I'm not saying we're going to find that, but if we were to find that, do you agree that as of the time that the female provides an explanation for where they were and what they were doing, that as of that point, there is probable cause to search the car?
Absolutely. Absolutely. Based on the female saying, yes, we went down to purchase drugs. But I'm suggesting This is a case about a trooper who had a hunch that drugs were involved, impermissibly prolonged the stop by ordering the people out one at a time to question them. And I do want to get back to Justice Meade.
Could I follow up just for 1 minute before you do that? Could I follow up on Justice Kinder's question? Am I correct that there was no evidence at the hearing of the duration of the stop? Is that correct?
One of the, I believe it was Attorney Bray who tried to elicit how long it took, because ultimately even a canine was brought to the scene. I think the trooper said it lasted as long as it took for the canine to get there, but he never put a figure on it. I think we could.
Go ahead, sorry.
I think we could assume that it was somewhat lengthy in duration in that he's ordered 3 individuals out at a time, then called for backup, spoke to Trooper Teedy, and also asked for a canine to come to the scene. Although no explicit time was ever put into the record, this was clearly not a brief temporary detention. I credit Trooper Leslie. When that white bag or object came out and hit his windshield, he had a hunch, given the context of the situation. It's 1:30 in the morning, a car with New Hampshire plates traveling through Massachusetts. And I think he had testified he had been involved in something like 300 various investigations into drugs. He had a good hunch that turned out to be correct. The problem is he extended his stop illegally. And I would point out again, getting back to, I think the question is ultimately, does the mere box of ammunition automatically give the trooper that reasonable objective fear for safety? In every case cited by the Commonwealth and by the judge, there was always more. There were furtive movements, which this trooper stated there were absolutely no furtive movements. There was no sign of evasiveness. There was no sign of nervousness. There was no sense of anybody trying to flee. There was no sense that anybody was not trying to make eye contact. These people were compliant, but he was following up on a hunch. And there was absolutely no case that stands for the proposition that that box of ammunition, birdshot, standing alone, caused safety concerns. In fact, during direct examination, the trooper never testified that he was acting out of fear for his safety. It was only during cross-examination when the motion judge interjected and said, well, isn't it possible that there could have been a firearm hidden within the clothing? And Trooper Leslie's not stupid. He said, yes, you're right. And then the judge said, well, describe the clothing. That's the first time that the issue of safety came up. I see that my time has expired.
Thank you.
Thank you.
Ms. Von Platten.
Thank you, Your Honor. Your Honor, the Commonwealth would request that the court affirm the verdict of the motion judge. With respect to his factual findings, you can accept those as found. There is nothing clearly erroneous about those findings. And then his application of law, the court will independently determine the application of law to the facts, and we would submit that his application of law was correct. And the Commonwealth's position is that, and it's supported by the record, is that the exit orders were proper because the trooper had a reasonable and objective basis for concern for his safety or that of others, based on the fact that he immediately recognized that box of ammunition in the back seat of the vehicle. It was 1:30 in the morning. There were 3 occupants in the vehicle. The judge did not make specific findings, but it's clear on the record that the car actually did take some time to stop when the blue lights were activated, so that it went by two exits on Route 91 and took a little bit of time to stop, but there was no finding about that, but that was clear in the record. But those objective facts supported the exit order for all 3 occupants. And there was quite a lot of testimony from the trooper. He said, when I see ammunition, my next thing that comes to mind is there's probably a firearm with ammunition. One doesn't have one usually without the other. He said, for all passengers visual confirmation that there were no weapons or the occupants was not possible. And in particular, Mr. Dargan was wearing a jumpsuit. He knew there was ammunition present, and he said, like I said, the next thing that my heightened alert would go to would be there's probably a weapon. And there were about four other statements that he makes with respect to his concern about the ammunition in the vehicle.
Ms. Von Flattern, the trooper's decision to direct the backup officer to conduct a search upon arrival, rather than assisting in any way, does run a little bit counter to his concern for his own personal safety, given the circumstance. Can you respond to that, please?
Yes, Your Honor. He testified that, Trooper Leslie testified that when he took Mr. Tuttle out of the vehicle, he told the other occupants to have their hands visible, one on the back of the seat and one on the dashboard. So the testimony was clear that he was well aware of those two passengers and was keeping himself safe by telling them not to keep their hands where he could see them. And the judge found that Trooper TT was only 0.2 of a mile down the road and very visible to the trooper if he needed him. So I think this case is distinguishable from Daniel, where the officer actually let the defendant drive, and if there was a concern about a weapon in the car, then why would you do that? But so I think this is distinguishable, and again, it's an objective basis. I think we can look at what steps the trooper took, but they were still consistent with a concern for his own safety and that of others. And then, as time goes on, he actually finds his concerns were not dispelled. He actually finds a single shotgun pellet or shotgun in the single piece of ammunition in the front seat. So it's not even, it's separate, it's different from the ammunition in the back. So his concerns were certainly not dispelled. And then he has concerns about, and there are objective concerns. One objectively could be concerned about inconsistencies in the occupants' stories. And then there was not clear testimony about how long the stop took, but it was, he got one occupant out, he got the other occupant out, he got the third occupant out. That individual went to Trooper TT's cruiser because he did come along. So there was not testimony that it was inordinately long before this proceeded, and the young woman in the front seat told the trooper that they had been to buy drugs, and my brother has conceded that then there was probable cause for the search of the vehicle. But there is case law to support the judge's finding that the frisk for weapons would extend into the car here. He had frisked each of the individuals. There was no, his concerns were not dispelled by that frisk, and it could extend into the passenger part of the vehicle.
Let me ask you a question about that. If I'm understanding correctly, at least as far as the trooper was concerned, I'm not seeing where the likelihood that any of those passengers were getting back into the car came from, because from the trooper's point of view, at the time that all three were out of the car, the driver had, in the trooper's mind, committed a criminal offense. The two other occupants had invalid driver's licenses. So where does the frisk of the car come in?
Well, I think, again, it's an objective standard, and I think the case law says that there can be a frisk of the car where a weapon could be reached by an occupant. In this particular, there was testimony that the other individuals had their licenses suspended, so they wouldn't be driving the car. But it wasn't necessarily clear that the cited driver who had a license wouldn't be able to drive that car away. And I think, again, it just goes to, it's an objective standard here, and the case law would support that. And I would say Judge Masick cites to Commonwealth versus Moses, which is clearly sets out that the search can, or the frisk can, frisk for weapons can extend into the passenger compartment. If there are no further questions, the Commonwealth would rest on its brief.
Thank you very much.
Thank you very much, Your Honor. And may it please the court, Jamie Rogers on behalf of Dana Tuttle. Ammunition by itself is not dangerous and cannot support a reasonable belief that the officer's safety was threatened. Instead, this court must look to the conduct of the people involved to determine whether there was a risk of danger to this trooper. The testimony here was that the trooper testified there were no furtive or suspicious movements at all whatsoever at any time by any of the people in this car. They were not nervous or combative.
Mr. Rogers, the Trooper Leslie also testified at some length that when he sees a gun, when he sees ammunition, it probably means they're a gun. There usually isn't one without the other. So
the fact of, thank you, Your Honor, the fact of a weapon cannot give, even if there was one, and of course we're not dealing with a weapon here, we're dealing only with ammunition, but the prospect that a weapon may be present is simply not enough here to raise a colorable concern for officer safety. And there are cases on point here, which we cite in our brief. DeJesus and Alvarado are the cases that I would direct the court to. In DeJesus, there was a 911 report of kids in a van with multiple handguns in a high crime area. The court held that report by an eyewitness did not justify an exit order of the defendant, who was the passenger in that case, because, quote, there was no reasonable basis for the officer to believe that he was in danger. And that was
ammunition in that car?
I don't know whether there were ammunition in that car, and I acknowledge that the ammunition here is analogous to a gun, but they are not the same. Certainly a gun would be more dangerous than ammunition alone. What we have here is ammunition alone. What we have.
But Mr. Rogers, excuse the interruption, but what do we do with the fairly well-established proposition in the cases that say we should not force a police officer to gamble with his own safety, where there is some evidence that a firearm might be involved?
Again, I think the court must look to the conduct of the people involved. The inquiry just simply cannot end, and the cases say that the inquiry does not end when there's ammunition or, more frequently in the cases, a gun. So I acknowledge that there may be some concern related to the fact that the officer or the trooper observes ammunition, but there was nothing about the conduct of the people here that could possibly give rise to a reasonable concern for the trooper's own safety.
Are there other contextual issues beyond just the conduct of the people, and putting aside the question of whether throwing something out the window, maybe that's a conduct by the occupants that could be taken into account, but the time of day, the location, the ratio of occupants to troopers, don't we take that into account as well?
I think they can be taken into account, but I'm not sure those factors, even in combination with one another, would be dispositive here. This is a motor vehicle stop that was initiated for a minor motor vehicle infraction by the trooper. In DeJesus and Alvarado, there were multiple people in the vehicle in each of those cases. And as I said before, those cases involved a gun. In Alvarado, it involved an eyewitness report of a gun wrapped in a towel. But again, the SJC said there was no showing of imminent danger to the officers upon their arrival. So yes, I understand there are other contextual factors here, all of which the trooper assumed, I think, by choosing to make the stop for this infraction at this time of day, and none of which would be dispositive here, none of which take that ammunition and turn it into something where the officer could reasonably believe that it was a threat to his safety. Justice Meade asked Attorney Oscar a couple of questions regarding the inconsistent stories. That too may be, to Justice Hand's point, an additional contextual factor here. I would suggest it's irrelevant. The inconsistencies were not between what the individual said initially and what Sanderson later said. The inconsistencies initially were regarding whether they had entered the casino, whether they may have stopped anywhere else along the way. Those inconsistencies were totally irrelevant to the reason for the stop. They were totally irrelevant to any legitimate concern for officer safety.
They're not relevant to the reason for the stop, but they are relevant to the evolving circumstances, including the admission of a crime.
With all due respect, Justice Meade, the admission of a crime comes much later. Sanderson does make a disclosure later in time that the purpose of the trip was to buy drugs. I'm not sure personally that that does furnish probable cause for a search, because the testimony is clear. She didn't know whether drugs were actually purchased, where they may have been located, whether they may have already been consumed, anything like that. So I'm not sure her saying that the purpose of the trip was to buy drugs furnishes probable cause to believe that there were drugs in the car. But even still, it's the timing of that disclosure that's most problematic. That, to Justice Hand's earlier point, there was no testimony regarding how long the stop was prolonged for the trooper to go back and re-question Sanderson, but it is clear that the stop was necessarily prolonged for him.
How do we know that?
Because those are additional actions that he undertook that necessarily require time to be taken and that were unjustified. In Cordero, the SJC says, in order to investigate a suspicion of further criminal activity, there must be specific and articulable facts in order to extend the stop to undertake that investigation. And here there were not. And the Commonwealth doesn't even argue in their brief that there were. The Commonwealth argues in the brief, I believe I forget the page number, the Commonwealth argues in its brief that the prolongation of the stop by re-questioning Sanderson was justified because of an ongoing effort to secure the scene, which, with all due respect to the Commonwealth, is just absurd, because nothing about the troopers' re-questioning of Sanderson at that juncture of the stop had anything to do whatsoever with securing the scene. Tuttle and Dargan had already been placed into cruisers, and the questions about where they had been, again, were totally divorced from any legitimate effort to secure the scene. Additionally, Your Honors, we have here an unlawful arrest of Dana Tuttle. The case is clear. Torres Pagan, I believe, is the most recent one. It's not cited in our brief. I believe it was published a few days after our brief was filed. In that case, the SJC said that the justification for a pat frisk is higher than that of an exit order. There must be reasonable suspicion both that the person is dangerous and that he has a weapon. Here, after being exit ordered, Dana Tuttle was pat frisked, but it didn't stop there. He was also placed into handcuffs and placed into the cruiser, which is tantamount to an arrest. It was a show of force by the trooper here that any reasonable person would have understood meant that they were under arrest. And that arrest was without probable cause. It was without probable cause for two reasons. One, because the trooper's demand for an FID card was untimely. It did not occur until after the arrest had been effectuated.
If Trooper Leslie was concerned for his safety, he's outnumbered. It's 1:30 in the morning. Aren't there sufficient case law to allow not only the separating but the actual handcuffing that don't conclude an arrest?
I'm aware of cases, Your Honor, where it has been held that there are circumstances that could make such a seizure a permissible part of a stop without transforming it into an arrest. But as Attorney Oskarn stressed, all of those cases, certainly all of the ones that I've been able to locate and look at, entail something more. There's a plus factor in all of those cases that's absolutely missing here.
Well, I grant you that there's no evidence of furtive gestures, but most cases involving exit orders don't have a revelation of ammunition in the car, right?
I think that's probably true. Again, I think that goes to my earlier point about whether ammunition itself is dangerous and could furnish.
Well, I mean, you say it's not dangerous, but Trooper Leslie said that it brings the strong connotation that a weapon is present.
We have cases, De Jesus and Alvarado, that cut against that idea, that cut against that idea, where there was not merely the prospect of a gun, but an actual gun that was reported to be present.
You conceded, Mr. Rogers, that those cases did not have ammunition in the car.
I'm conceding that there may have, but we don't. With that being said, I'm not conceding that the guns were unloaded. That I don't know.
No, I'm saying, did those cases involve a stop of a motor vehicle that had ammunition in it?
They did not. Those cases, I think, involve something more egregious, something that would clearly raise a higher or a greater concern for officer safety, which was the presence of a handgun. of a gun, an actual gun, and not merely ammunition. The second reason why the trooper's arrest of Dana Tuttle was without probable cause is because at all points throughout the course of this stop, the trooper was laboring under a mistake of law. The Commonwealth has conceded this. So that the Commonwealth seems to suggest in their brief that it doesn't matter, but it does matter because it's a separate and additional reason why the arrest of Dana Tuttle here was unlawful, because his possession of that ammunition was lawful under the statutory exemption, which
if we conclude that Mr. Tuttle was not under arrest, does any of this matter?
Much of this matters. Yes, I believe much of this matters. Again, because
I'm sorry, my question was vague. The mistake of law issue.
Well, yes, because there's an initial independent reason why. Well, I'm sorry. The question is, I'm sorry. Could
I'll rephrase it. If we decide that Mr. Tuttle was not under arrest when he was handcuffed in the back of the cruiser, does the mistake of law issue matter anymore?
I think it does matter. It may matter less, but certainly Dana Tuttle was ultimately taken to the barracks for booking. He was not released from custody. So if the court disagrees that an arrest was effectuated at that point in time, the mistake of law issue, although perhaps not dispositive, is still live because Dana Tuttle was not allowed to drive away. So he was arrested at some point in time, and that was without probable cause for the two reasons that I'm now emphasizing.
The motion judge dismissed that charge.
The Commonwealth, thank you, Your Honor. The Commonwealth null prossed the ammunition charge, which I believe appears at count 1 of the complaint against Dana Tuttle after the motion to suppress hearing. So yes, the drugs that were found later during a search of the car are the only evidence remaining in this case. But certainly Dana Tuttle was arrested at some point in the course of this stop.
And he was arrested for possession of the drugs, right?
I mean, no, not according to the trooper's testimony.
Is he charged in the complaint with possession of narcotics?
Yes.
Thank you.
There's some discussion and argument in the briefs regarding whether the statutory exemption provides an affirmative defense. And I don't think there's any dispute between the parties that indeed it would and could form an affirmative defense. But that doesn't mean that it can only be raised as an affirmative defense and that it cannot be raised at a motion to suppress. We attempt to address this in note 2 of our brief. I would suggest to the court that it's analogous. The ammunition here in the prospect of the statutory exemption being raised as an affirmative defense is analogous to the possession of an FID card to justify having a gun in one's possession, which, you know, there are cases that clearly state that not only is that an issue that can be raised at trial as an affirmative defense, but can be raised in a motion to dismiss as well. Again, it seems to me that the court is placing some emphasis on Sanderson's ultimate disclosure that the purpose of the trip was to purchase drugs. It also seems to me that the motion judge and the Commonwealth, with all due respect to both, have overlooked whether that disclosure was lawfully obtained. And here, under Cordero, I would argue that it absolutely was not lawfully obtained. And the Commonwealth has not argued in their brief, and I do believe it's on page 20, that the prolongation of the stop that was necessarily occasioned by that re-questioning was justified under the standard set forth in Cordero. As to the search of the car as justified by a protective frisk, I appreciate Justice Hand's questions earlier. A protective frisk is a limited search for weapons. That never happened here. There was a full search, an investigative search of the car at a time when a protective frisk would not have been permitted for two reasons. One, because as I've attempted to emphasize throughout, the conduct of the people here made it such that no danger was actually presented to the trooper. And two, because by the time the frisk of the car was undertaken, no one was re-entering the car. And if it's not clear from the record that anyone was going to re-enter the car, such as Sanderson, to get a personal item, that would be the Commonwealth's fault in their failure to discharge that burden at the motion hearing.
Thank you.
Thank you.
Ms. Von Platten. You need to unmute your mic.
Sorry, Your Honor. Cynthia Von Flateren, for the record, Assistant District Attorney for the Commonwealth. The Commonwealth submits that the judge's findings of fact were correct and his application of law to this case was correct. I think in my brother's brief, he talks a little bit more about the fact that the residents of the vehicle were from New Hampshire and there was a statutory exemption that made it clear that the charge for unlicensed possession of the ammunition was not correct. But as the judge found, it doesn't matter if the ammunition was ultimately legally possessed or not in terms of the safety for the trooper. It doesn't matter if it's lawful or not. He specifically testified to his belief that if there was ammunition in the car, that there was probably a gun in the car. And even if that gun was lawful, he still had valid, reasonable concerns for his safety. So
what about the fact that the driver was arguably under arrest, would not be getting back into the vehicle, and that the other drivers were not in a position to drive the vehicle away? So if no one is permitted to re-enter the car, doesn't that undercut the need for a frisk car?
Well, and I know this was brought up in the first case. I think that the case law is that there can be a protective frisk of the vehicle that can extend into that passenger compartment. And the court has talked today about the trooper's actions with respect to Mr. Tuttle were to protect his safety while he was investigating this case. The investigation was not over, and it was entirely reasonable for him to separate Mr. Tuttle and put him in the cruiser while he was dealing with the other two occupants and dealing with what was going on in this case, including whether there was actually whether any of the occupants were armed, because he had not pat frisked them yet, and then after they were pat frisked, whether the vehicle contained a gun. So it's possible. I know there was testimony that the trooper believed that he had grounds for an inventory search, which would be necessary if the car was going to be secured. But if Mr. Tuttle was being kept secure because he was being validly kept secure because of the security concerns. So I think objectively, we don't have to get to the fact that the occupants might not get back into the car. But again, they could be getting back into the car for their own items. They were taken out. It was entirely possible that they would have to enter to get their own personal items out of that car. And so the brief time that it would take and reasonable time that it would take for the trooper to conduct a search for weapons was reasonable in this case and justified, regardless of whether they were ultimately going to be arrested. And then, of course, very quickly, the cocaine was found in the car, and then there was probable cause for the arrest of the occupants. So it moved very quickly, but each step of the way, I think that the concern for safety justified the steps that were taken. Are there any other questions for the Commonwealth?
Seeing none, take this under advisement. Thank you both.